Washington, D.C. Welcome to a pre-show webinar with Thomas Cohen. That's a pre-show referring to the Telecom Access Networks show, one of the conference tracks, a new one this year at the 2011 NAB show in Las Vegas, coming up in April. The Telecom Access Networks show specifically is April 11th and 12th, Monday and Tuesday of the show. And as I said, a new conference this year with also a new Telecom Access Networks pavilion on the show floor. And this program is a little bit of a précis to that. We'll be telling you a little bit more about the conference itself at the end of today's program. But for now, I want to let you know that first of all, we are recording this, and this recording will be available on the NAB TAN conference, the Telecom Access Networks Conference website, in a couple of days from now, perhaps as early as tomorrow, but certainly later this week. All registered attendees to this webinar today will receive an email with links to the on-demand portion and the presentation slide deck. Questions today are encouraged throughout the event. If you're watching this, listening to this on your computer, you'll see an area on your client there for viewing the GoToWebinar that allows you to enter questions in text, and we'll address them at the end or in follow-up communications if we don't have time today. And if you do experience any issues during this event, please email webinars@bia.com for assistance. That's webinars@bia.com. We will be going for about an hour here, and look forward to some really interesting presentations from our panel today. Actually, our primary panelist is Thomas Cohen, and you'll be hearing about him in a moment. This is a sort of a predecessor to the conference itself, talking about regulatory issues. Most of the stuff at the conference will be more technical. But to tell you a little bit more about that, why don't we introduce a real telecom expert, and that's Joe Savage, who some of you may already know. Joe's been around for a while in this business, more than 40 years of executive-level experience, in fact, in broadband access and optical networking. From 2005 to 2010, Joe served as president of Fiber to the Home Council North America, an association that's accelerating next-gen broadband. Joe began his career in fiber optics in the 1970s, helping to build the first fiber production facility at Western Electric in Norcross, Georgia. Joe's a PE with an MSEE from Georgia Tech. He's received patents for high-speed digital transmission cable design and for methods of avoiding internet congestion in the public switch telephone network. So without further ado, let me introduce Joe Savage. Joe?
Thank you, Skip, and good day, everyone. Yes, the Telephone Access Networks Conference is going to touch on the key element as far as deployment and expansion of broadband, the application that's driving the need for all fiber access and fiber to the X deployments in North America and around the world is video. And video services, making money from video services is a very elusive and ever-changing process. And the TAN conference is going to focus on much of the technology, the equipment, the network design, and the how to have a network that provides superior competitive broadband access, so that once you've paid the money to put the network out there, you can actually make the money to pay off your capital. While the conference is going to focus on the technology, in the background or in another dimension, the regulatory and legislative issues that affect the pace of our industry are becoming more and more significant, starting 5 years ago with the wars over streamlined video franchising, and more recently with all of the activities around network neutrality and now the National Broadband Plan. It's a good idea to get this into your awareness so that you can have it as a background upon which to base all these technology solutions. And here to talk to us about that is, I can't think of a better expert in the United States, Tom Cohen, who is a partner in the Washington, D.C. office of Kelley, Drye, Collier, Shannon. He's got more than 30 years experience in telecommunications, first as a government policymaker, serving for over a decade as Assistant General Counsel for legislation at the Federal Communications Commission, and then as Senior Counsel for the Senate Commerce Committee. Tom was very involved in the Cable Act and Telecommunications Act passing into law during that time. At Kelley Drye, Tom assists clients with a variety of aspects of communication law, including federal and state administrative and legislative advocacy, business-related legal matters, and litigation. He's been the Washington counsel for the FTTH Council for the past 5 years. And with that, I'm going to turn it over to Tom.
Well, thank you, Joe, and good afternoon, everybody. As Joe said, I'm going to talk today about factors driving network deployment, factors from the Washington side, regulatory, legislative, legal issues that affect your revenues and your costs for these networks. And I'm going to particularly dive into sort of two of the three revenue streams that network providers have. Broadband, where the margins are quite good these days, and most network providers see it as the key revenue stream for the future. And then voice services as well, where many network providers have entered. It's a much more complicated marketplace than it used to be, but you can still get some pretty good margins on it. And in both instances, broadband and voice, there are a host of issues coming from the FCC, from the Congress, and even from states as well, which we won't really hit on, affecting those revenue streams and those expenses. So with that, let's go to the next slide, and this is sort of the agenda that I'll talk about. First, we'll talk about the FCC's Open Internet or Net Neutrality Order. We'll talk about the status of it, some of the key requirements which will affect your opportunities to make money, as well as cost and liability requirements. And then we'll touch just briefly on the recent dispute between Level 3 and Comcast. And then we'll roll into the sort of follow-on issues of the National Broadband Plan, and there are three I'll want to discuss. Discussing sort of the voice and broadband areas, we'll go through the new universal service funding proposal as well as the changes to InterCarrier Compensation reform. For the smaller telcos particularly, these are critical items to their network deployment issues. We'll also go to something called the SAM-nose testing. That's Broadband Performance Measurement. And the FCC is very keen on this testing so that people know their actual broadband speeds and the capabilities that result from having those speeds. And then finally, we'll just talk briefly about the most recent Broadband Acceleration Agenda proposed by the chairman, and certain items on that agenda are going to hit relatively quickly. So with that as the overview, let's roll into the Open Internet Access Order, which was adopted by the Commission in late December, a party line vote of 3-2. The order itself has not yet been published in the Federal Register. This is now, we're several months later, and it's still not officially published, but as you'll see, activities are moving forward. First, because the order imposes new disclosure requirements and a new complaint process, it must go through vetting at the Office of Management and Budget. And comments are due on that on April 11th. And I expect various broadband service providers to comment because of the burdens imposed by the order. It's unclear how long OMB has to respond to those comments. The FCC really can't move forward until they do. But once they do respond, and assuming they have no changes, the FCC's order takes effect 60 days later. So guessing right now, it's not likely the order is going to take effect until the third quarter of this year and potentially later. But you need to be aware, as you'll see when we go through the requirements, of what may be coming your way as a broadband service provider. In addition to the... Yeah, Joe, go ahead.
We've got a question already.
Good.
It's something to the effect, is Jules Denikowski going to be able to get out of Dodge before these rules take effect? And has anyone actually put in a complaint under this order yet?
Okay. Whether he is able to get out of Dodge is beyond my pay grade. You know, they say only fools and newcomers make predictions like that, and I am neither. So I'll stay away from that. But no, you can't file anything yet, any complaint yet, because the rules are not effective. So anything that people may file, they have to allege a violation of other FCC rules, but not of these open internet rules. They're not effective yet. The other track where action is happening, actually there are two other tracks. One are the courts. And both Verizon and Metro PCS have filed in the D.C. Circuit, the federal circuit here, appealing the decision. However, it's unclear they were entitled to. Generally, the race to the courthouse begins when the order hits the Federal Register, and that hasn't occurred yet. At the same time, Congress is challenging the rules. And they're doing it in two ways. One is there's general legislation that's been introduced to deal with it. And that will occur, if it is heard at all, over a longer period. But there's something called the Fast Track or the Congressional Review Act. And it's a roughly 60-day process for the Congress to pass a law overturning the rules and have the president sign them. And that can be overridden by a veto. Last week, the House Republicans took the first step in that process, and the House Communications Subcommittee voted out on a party line vote a resolution overturning the rules. It will likely go through the House over the next 3-4 weeks. The problem will come in the Senate. And whether it can get through there, and then, of course, whether the margins by which it can get through are sufficient to override a veto, and the odds at the moment are slim. So for a broadband service provider thinking about this and what they're going to need to do, you need to prepare to implement the rules, because I don't think Congress is going to be able to overturn them unless something unusual happens. And court appeal hasn't begun, which means we're probably not going to see a result in the courts until sometime next year. So with that as the setup, sort of the overview of the rules, let's go through what the rules say. And first, what you're going to see is the rules apply to both fixed and mobile broadband service providers. And the rules are a little bit different, though, for mobile providers because of sort of the capacity constraints of the spectrum versus fixed providers. It's also just critical to understand what they apply to, because the definition of broadband internet access services is very specific. Okay, it's a mass market service. It's got to be offered, you know, at retail, and it provides transmission to and from substantially all internet endpoints. Now, if there are functional equivalents, that will come into it as well. So, as I said, who it applies to is very specific. At some point there was a thought that it was not going to apply just to broadband service providers, but to content or applications providers. That didn't occur. And as well, the definition is relatively restricted. Mass market includes both residential and small business, although the line is hazy about what small business means. And as you know, I use that word hazy. I could use that frequently in this discussion about the FCC's rules. And normally, being hazy, well, it may not be all that important, although you do want some certainty to operate your businesses. But here, because of that, you really have to think carefully about liability. And we'll talk more about that as we go on. So going to the next slide, let's talk about the 4 big areas where there are new FCC rules. First one is the disclosure requirements. And as you'll see in a minute, they're quite extensive. Secondly, broadband service providers cannot block traffic over a broadband internet access service, and you have a duty to permit connection of devices. Third is this general non-discrimination rule, and it's no unreasonable discrimination. There's a bit of room here. And then finally, the sort of caveat to a lot of these rules: providers are permitted to engage in reasonable network management practices. So this is the framework of these new rules. Now let's go through each of the requirements. First, the disclosure requirement. Broadband internet service providers have an obligation to disclose information in 3 areas: your network management practices, your network performance, and your terms and conditions for providing service. Now, what the FCC has done here is provide sort of a series of categories of things you're supposed to do, but it is not complete, and it does not provide a safe harbor. So this is the part, remember I talked about Office of Management and Budget holding a review process to see if these rules are too burdensome. This is what they're focusing on. And what you're going to see is you need to provide quite a bit of information. For network management practices, you need to talk about, in general, how you manage your network. Congestion issues. What do you do when there's congestion? Do you deal with different applications, disparately when you do that? What about people who want to attach devices to your network? Are there rules for them? Okay? So that comes under network management. Under network performance, there's one requirement that stands out, and that is measuring the actual performance of your network. Generally, people these days talk about their advertised performance and talk about speeds up to a certain requirement. Here, you're going to have to talk about your actual speeds and actual performance in other areas. This is a new requirement that's leaving a lot of people stumped about what does it exactly mean, how do they measure, and therefore what their requirements are going to be. Some of you may have seen past week a news story about consumers bringing litigation against Clearwire, the fixed wireless provider, about sort of unfair and deceptive practices regarding its advertised broadband internet access performance. Well, that's, relatively known, but here we're going to actual. And so there becomes another ground for people to come after you. Also, you are permitted to offer what's known as specialized services, which really are services, and people are still trying to define them, but sort of managed services, services designed to help businesses, smaller businesses, since that's what's covered by the rules, to have greater in general network performance, which may include access to the Internet. The FCC is concerned that a broadband service provider is going to game the system and sort of replace this general broadband Internet access service with a specialized service or a group of specialized services. And therefore, it wants you to talk about what you're doing with those services. And then finally, there is the category of terms and conditions of your service. You know, the item I put here is fees for early termination, but there can be other terms and conditions. I know many service providers are already aware of their privacy policies and posting them. That as well must be included.
Hey,
so,
Tom.
Yeah, Joe, go ahead.
I like the question. It's like the FCC disclosure requirements appear to be nearly as complex as applying for the broadband stimulus grants. And are there any examples of satisfactory postings or disclosures, or is there any guidelines?
Well, in fact, Joe, let's go to the next slide, and then I'm going to answer that question, because the next slide goes to when do you have to disclose the requirements, and that'll help sort of answer the question. You have to disclose at the point of sale, on your website, and whenever you think, you've made a significant change in them, you need to revise them, and the FCC is not explicit about how that occurs. So now let's wrap back up into your question, and there is nothing out there. There is no template. Remember I said there is no safe harbor, and the FCC's list may not be exhaustive. So what you need to do, unfortunately, is, boy, I hate to say this, think like a lawyer. Or get your lawyer involved, because what you're always thinking about, unfortunately, is liability. And we'll get to the complaint process later on. But you have to think about those words you put out there and what someone may take those words for, rely upon them, and act on them, and therefore what is your liability. And as you can see, or as many people know about their networks, there are real issues about how often you change your network management practices, for instance, as new threats occur and have to update. Or you roll out new services, upgrade them. And what do you do about, revising the performance? Do you have to test again? And what do you have to say? I spoke the other day to a network provider who offers service as DSL, cable, and fiber to the home. And each one is going to require something different for this person to post on the website. So back to you. Do you have more to say or a question?
No, that was it.
I'm sorry for my answer. I wish I didn't have to give an answer like that. I wish, we had some greater certainty for people. That is a safe harbor. But that's not what the FCC has done. So if you are concerned about this, you do have some immediate recourse, which is file comments with the Office of Management and Budget by April 11. And say, boy, this is confusing. This is not, it's burdensome. Because I change my network management practices, or I roll out new services 3-4 times during the year, or other things that you do, and this is just unreasonable.
So if I say something in my disclosure about we reserve the rights to modify our network management techniques on the fly as required by changes in threats, that probably wouldn't be...
No, you need to be more specific, because what they're thinking about is put on the hat of an applications provider who needs to navigate your network, or some end user who wants to publish and send stuff upstream. And they want those people to be able to go to your website and get an idea of your network management practices, say.
Okay.
And I'll get into the network management a bit more about, what they expect there in a moment.
Okay.
So yeah, it's not. I don't think it would be sufficient. Okay, let's then move on from transparency to no blocking. This is relatively straightforward. And here there's a divergence between fixed broadband internet access providers and mobile ones. Fixed have a greater burden. You can't block lawful content application services or the connection of non-harmful devices. Mobile is different. You're prohibited from blocking access to lawful websites and applications that compete with your voice service. So a provider couldn't block Skype service. It's, as I say, much more limited. And blocking obviously would extend to beyond just outright blocking, but to impairment or degradation. Now, finally, as you'll see at the bottom of the page here, you are allowed to use reasonable network practices to deal with congestion as well. And so again, when you invoke that and you have to block because your network is being overwhelmed, it's okay. But as you'll see, it's much better, and this, Joe, goes to your point, to have already provided notice that if my network gets overwhelmed, here's what I'm going to be doing. And, you don't have to give away state secrets, but that greater transparency will help you deal with the no blocking rule. Okay, that's the second of 4 rules. Now we'll move to the third, the non-discrimination rules. And as I said, it's unreasonable discrimination that you're prohibited from engaging in. This is sort of a traditional common carrier term. And so there is such a thing as reasonable discrimination. And what's the FCC going to look at here? And again, here are some factors. The list is not exhaustive. Just because you do these things doesn't mean you have a safe harbor. But again, the greater the transparency of your activity, the better you're going to be doing. The more you give the end user control, the better off you're going to be. You are permitted to tell an end user, we are going to meter your traffic. We are going to preempt your traffic if you want to sign up for this type of service. All of that sort of comes under the heading of the end user will make a choice about the service to take, and then we'll know about the practices that follow. There was a recent discussion about a wireless service that sort of said to subscribers, under this service, you're going to get access to YouTube, but you won't get access to other video sites. And there have been, people talking about complaints about that. That one seems to me to be, I would think, a little on the edge, because you have to look at what's the underlying reason you're restricting access. If it is to say, I don't want my network overwhelmed, why will YouTube be any different than another video site? So, there's still some concerns here, and we'll see how these play out. The more you operate in conformity with standard practices, the better off you are. And on and on. There are other issues here. One that draws, concern from the FCC is what's known as pay for priority. That is, I will give you a faster route to your customer if you pay me money. This is not out and out prohibited by the FCC, but you better have a good reason for doing this. And I can think of reasons for doing it, but you really need to work through this carefully so it doesn't look like you're unreasonably discriminating. And then finally, we can move to the last piece of this, the reasonable network management practices. And the FCC tailored a solution here that is different than the one they used in the Comcast BitTorrent order. In there, they said the reasonable network practice must be the most narrowly tailored solution to the network issue. Here, they're more open. It has to be just appropriate and generally tailored to achieving a legitimate purpose. So it's a little looser. It's going to depend on your network platform, your architecture, your technology. Again, like everything else here, the Commission is not going to tell you exactly what you're allowed to do, but if you're really concerned, you can ask the FCC. It's going to be a real interesting process to see if the FCC takes people up on that and actually gives a prompt response. That is one that works for you in terms of your business. And of course, issues dealing with network security and reliability are ones that generally will pass muster, and ones dealing with congestion should as well, so long as they are more of a standard type. So those are the 4 rules. There are a couple of other points that you need to know about with these rules, and these are on that next slide. Broadband providers are permitted to monitor issues of copyright infringement and other unlawful activities, and to cooperate with law enforcement. I don't think either of these should be a surprise to anybody. So now we have the setup for the rules. Let's go to the next slide, and we'll see how they're enforced. And the FCC said they're going to get enforced through 3 processes. One is an informal complaint. And under an informal complaint, someone writes to the FCC and says, my broadband service provider has done the following, and the FCC says, we'll send it to them and give them an opportunity to respond. And generally, that's it. That tends to be the end of the process at that. Maybe there's a little bit of work to negotiate a resolution, but it rarely escalates. It doesn't involve a lot of resources, the time for a broadband service provider to do a little bit of research and respond to that letter, but that's it. In contrast, there's the formal complaint process. And here, it's like full-blown litigation. First of all, the allegations must be like a complaint in litigation, with all the facts that are required. It just is not a simple letter. It's really, a complaint with a brief, in effect. It's expensive for someone to go out and bring this. Then, for the broadband service provider, you need to respond in kind. And there will be strict time limits to do that. It's a very intensive process and an expensive one, not surprisingly. And then finally, if the Commission begins to see patterns out in the market that they don't like, they can conduct their own investigation. So those are sort of the enforcement mechanisms. Who can initiate complaints? Anyone. And so now we circle back to where we started, talking about disclosure, transparency. And at any time, you could find yourself as a provider hit by a complaint. And so the FCC, just a second, Joe, has created just a whole new area of liability.
I mean, every service provider has those dozen or so painful subscribers that they wish they could have sent to their competition. Is this a path where, I mean, at what point does a person rise to a nuisance by writing letters? I mean, there is that possibility, isn't there?
Yeah, I mean, you could have multiple letters being sent your way, and you need to respond to them. And it's like, you know, they could complain to you directly and you might respond. They could complain to the state consumer office. Maybe that triggers a response. This is, you know, with informal complaints, it's sort of in that area.
Okay.
So, you know, it's just, it's an annoyance, is what it is. The big issue is, to me, the formal complaint process and opening it up to what I will call the plaintiff's bar, the people who bring class action suits, and whether or not they'll want to see this as an avenue to go after broadband service providers.
Okay, thanks.
All right. So that's the FCC's order where it is. Now let's just do a minor diversion and go over to the Level 3 Comcast dispute. And what this is Level 3 has become a content distribution network. They've signed up Netflix recently, so they want to, you know, lodge their servers near endpoints. That is, you know, with each broadband service provider's network, so their traffic can go across more quickly. And they came to Comcast and said, we want to do this and put our traffic through, and Comcast said, well, we need to reassess the compensation scheme between the two of us. And Level 3 has escalated this to the FCC. My guess is they've taken it to the Department of Justice, maybe state attorneys general, I don't know. And they want, though, with the FCC, them to act as it's in violation of the Open Internet rules. Well, first of all, those rules aren't effective. Second of all, it's unclear that this is a broadband Internet access service. And that instead it really is not anything different than a normal peering dispute between Internet backbone providers. And so that all began last December, I believe. We're now 4 months later, and not a whole lot has happened, and it's unclear the FCC really is going to undertake an investigation of this right now. So it will be interesting to see if the parties themselves get together to work this out. Okay, so now we've gone through Open Internet order. Let's move to the National Broadband Plan implementation and the major issue that's teed up right now. At the February 8th FCC open meeting, the Commission adopted reform proposals for both universal service funding and inter-carrier compensation. And why is this important? Because for both Tier 2 and Tier 3 telecom providers, a significant percentage of their monthly voice revenues come from inter-carrier compensation and universal service. Particularly for the Tier 3 rural telcos, on average, about half of their monthly revenue comes from these two sources. And the FCC is proposing to reduce them significantly, taking down universal service funding for the smaller carriers by roughly a third, for the larger providers by a significant amount, and then reducing their inter-carrier compensation payments significantly as well. So there's a lot of money in play here. We're talking many billions that are going to move around, and when they move, they will go out of the pockets of the local phone companies, as I say, the smaller ones primarily, and go into the pockets of the long-distance entities or other players. So this is a real personal issue for rural and mid-sized telcos. I will also add, it's also an issue for cable entities that are in the voice business as well. Now, the FCC has put forth a pretty rapid comment cycle. The USF comments come in first on April 18, and the InterCarrier Compensation comments, some of them come in on April 1, some of them on April 18. The FCC very much would like to deal with this issue by year end. I think it's going to be tough to do it. Yeah, Joe.
There's a sentiment of doubtfulness that, is this not the issue that the prior FCC chairman, fell upon his sword, and it's been around for a very long time, but nobody's been able to actually affect a reform?
Yeah, that's an excellent point. Some of it is due to a lot of factors. The FCC has abdicated its responsibility in many areas. The last reform was over a decade ago. Mm-hmm. And to consider this historically, the system was all put in place at the time of the breakup of AT&T, some 27 years ago. And, at that time, what's known as switched access rates, that is the payments long-distance companies made to local providers, was in the range of about 18 cents on average. The FCC has successfully dropped that to roughly a penny on average today. So it's come a long ways down, but there are significant arbitrage opportunities in intercarrier compensation. Intrastate rates differ than interstate. Traffic that is transmitted by IP technology differs than the rates differ potentially from those for TDM technology, and wireless and wireline rates differ. So you have this sort of messed up system at the moment, tremendous arbitrage opportunities, a lot of uncertainty, which slows down investment, a lot of self-help, a lot of litigation. So yeah, there's some real problems, and a lot of it goes to the doorstep of the FCC. Can they move it in the right direction? We'll see. They're going to try to. On the issue of USF, they want to move to a broadband era fund. And so there's a real reason to do it, but it's going to take quite a bit of lifting. When Kevin Martin was chairman, he almost got something through in 08. There are various reasons people think why he didn't, but he got pretty close. We'll see if this crowd can get close as well, or can they get close on, maybe the proper way of looking at it is on which issues, how much can they get done? Okay, it may not be all or nothing. So we're all going to play this out. There's going to be a tremendous amount of activity. Let's go to the next slide where I've sort of set forth where we are. The major rulemaking here is the High Cost Universal Service Fund. $4.4 billion annually goes out the door. That's about half of the overall USF funding. About half of that money goes to the smaller carriers, about a quarter to the mid-tier and Bell companies, and then about another quarter to what's known as the competitive providers, largely wireless entities. So that's who draws from the fund today. The FCC also, and just recently, teed up another proceeding for Lifeline and LinkUp funding, which is about now today a little over $1 billion of funding there, and so that's moving on a parallel track as well. And the FCC hopes to soon launch a proceeding to deal with the contribution reform side. Right now, the fee or tax on interstate telecom services is approaching, or I think next quarter is approaching 15%. This quarter it is, and that's a pretty steep tax to pay. they're thinking of how to broaden the base. So as I said, the FCC, if we go to the next slide on USF, has teed up its reforms. It's a two-step process. They want to reduce the payments to the rate of return carriers and other Tier 2 carriers as well. They want to, over 5 years, squeeze the competitive carriers and reduce that funding. And they want to create a new broadband fund, the Connect America Fund, where they're going to award via capital grants money to build out a broadband plant in unserved areas. So this is a sort of a new paradigm for the FCC. Earlier someone talked about the complexity of the broadband stimulus program. The FCC is looking to use reverse auctions here instead of sort of the beauty contest there in order to give out these awards. It's a new undertaking for the FCC, and if anybody reads the text of the 300-page proposed rules, they're asking for incredible detail about how the process should work. And I should finally note the FCC wants to do this without expanding the size of the fund. So they're going to squeeze current users, free up money, award it in unserved areas instead of high-cost areas. Now, that's the short-term vision. The FCC has a long-term vision where they really want to target support to areas where there really isn't an economic model to build broadband. And then they ask a series of questions about the options in order to pull that off. This is more open-ended. You know, when we talked earlier about what the FCC can do, this one's down the road. I think they focus on the short-term reform and deal with this much later. Moving on to the next slide, let's go to intercarrier compensation. There are some riper items that the FCC wants to deal with right away. First of all, the FCC has abdicated its responsibility to determine the classification of VoIP traffic
Tom,
and what it should pay. Yeah, Joe.
Could you step back and just, in 2 sentences, what is intercarrier compensation?
Sure. Intercarrier compensation, actually the name is not bad, Joe. It's relatively descriptive. When traffic is exchanged between two carriers, there's a question about should one carrier pay the other. The classic model is a local phone company originates and terminates traffic for long-distance companies. And so long-distance companies have paid local companies to do that. And that's the real focus here. There's also exchange of traffic, say, between two local providers, a cable company and a telco. The reforms here really are focused on what's known as switched access charges. That is the payments from long-distance companies to local companies. And so the first issue here is, traditionally it's been TDM traffic. How do you deal with VoIP traffic? And there's been a lot of litigation around this. The FCC has not spoken, which doesn't mean there aren't payments due, but they haven't spoken. The FCC asks, okay, how should we classify that traffic? Is it like basic voice traffic, really, regular service, or should we move it over into the IP world? Okay. There are then 2 other issues, something called phantom traffic, where the traffic is not properly labeled. So when you get it, you don't know how to charge for it. And should the FCC impose new rules to require people to identify their traffic when they pass it off? And then finally, there is the world of traffic stimulation arbitrage, which is a new arbitrage scheme where conference calling entities give out free service in exchange for revenue sharing agreements with local phone providers. These 3 items are the hot ones at the FCC. On the latter 2, the proposals are more specific. And here, comments are due in 16 days on April 1. Then there's the larger issue on intercarrier compensation. Remember I said earlier the FCC has pushed down those switched access rates from 18 cents to roughly a penny. The Commission believes those rates should go down even farther and is asking about how do they do it. So remember I talked before about the different arbitrage opportunities. One is between interstate and intrastate rates. The FCC wants to unify those rates. It wants to unify the rates for VoIP and TDM traffic. It wants to unify the rates for wireline and wireless traffic. After all of the traffic goes over the same local facilities. So a minute is a minute. Why don't we have the rates unified? And the FCC wants to unify them at a lower level. So it has a whole series of questions about how to do it, but the proposals are not all that specific. Going back to the question before, how quickly can the FCC act? It's unclear until they get a little more specific as to exactly what they want to do. Now, a complicating factor here is when you push down on intercarrier compensation, remember, as I said about smaller local phone companies, they depend on it. And what we've done in effect is this is an implicit universal service subsidy, and now it becomes explicit. There's something called, what they're talking about as a recovery mechanism, a new universal service fee that may come out of this. How big is that going to be? Who's going to pay for it? So this is a complicating factor as you shove down intercarrier compensation rates. What happens in terms of the need for a greater explicit universal service fund, and who will get access to that money? So that's the big fight going on now in this world, and greatly affects the revenue streams of these smaller carriers and therefore their ability to build broadband plant, network plant. Smaller carriers, particularly rural ones, used to take universal service money and go to their bankers, either the RUS or CoBank or somebody, and say, we're getting this stream of revenue from universal service, give us a loan so we can build out. All of that becomes, comes into play now. Okay, we only have a few minutes left. Let me quickly hit two other issues. One, broadband performance requirements. Apart from looking at actual speeds in the Open Internet order, the FCC is trying to determine how you measure broadband performance. And right now, ongoing, they have a contractor known as Sam Knows conducting a test with ISPs of different types about their broadband speeds. They've given out 10,000 modems to users, and results are starting to come in. And sometime in the second quarter of this year, the FCC is going to publish its first results. And the biggest concern for broadband providers is sort of the discrepancy between what they advertised and what are the actual speeds. That becomes much more important, say, for DSL providers. It's not that important for fiber to the home providers, and sort of middling for cable providers. So that's all in play, and at some point it may result at the FCC in sort of a labeling standard or disclosure standard that you have to talk about that is a little more apparent than what we talked about in the Open Internet rules. And then finally, on February 9, the chairman launched a new Broadband Acceleration Agenda. A lot of this deals with infrastructure issues, pole attachments, access to rights of way. I expect a vote on the pole attachments order, I think in April is where they're headed right now. And that will talk about both lowering the rates and making it easier to access poles of private utilities. And then they will launch an inquiry into getting access to rights of way in general. So there we are in talking about sort of network development. Joe, let me give it back to you.
Okay. Well, thank you, Tom, for that enlightening. I mean, it was like an hour to present the Gordian knot, and there still seems to be an awful lot of activities underway. For those in the audience, what might you suggest that if they're interested in improving delivery of video services, what actions might they take either with their congressional delegation or with the FCC?
I think education is critical about their sort of business model, what it's going to take to deploy, what barriers they see in their way. Seems to be the most important things right now.
Okay.
If they are saying I can deploy more, if the following 1, 2, or 3 things are not in my way, that becomes real relevant.
Okay, and the comment there was a short-term Office of Management and Budget. Oh, that was if anyone wanted to comment on the weightiness of the burden of the new FCC rules.
Right, exactly.
Where might they go in order to submit that? I mean,
the FCC is taking those comments for the Office of Management and Budget. And there was a notice published in the Federal Register on February 9, I believe.
Okay. And then there's a question about broadband auction. And this is having to do with the broadcast channels.
Great. That's, I mean, if we had another hour, we could talk about all of that. That's going to require legislation. And that's a big issue up on the Hill this year, working with the administration, trying to figure out if they can free up spectrum in the 700 megahertz band by sort of repacking the broadcast stations, and whether or not certain broadcasters would be willing to, in effect, give up their rights to their station for a payment. This is a real interesting issue, and it has a long ways to go.
There have been suggestions.
I think it'll be driven by the budget. There is a need to raise money in the budget. I expect them to say we need to auction this off, and that will drive the process.
I've heard sentiment amongst the House that maybe they should try this experiment of auctioning off the spectrum with National Public Radio.
I have no comment.
Okay.
That's not a lot of spectrum. That's radio. It's not like TV.
Okay, well, we are out of time, and thanks again, Tom, and I'll turn this over to Skip to wrap it up, please.
Well, thanks, guys. Terrific stuff. Very interesting and educational for us all, I know. Thanks, Tom, for all your time in both presenting and in, of course, preparing all this excellent material and very well synthesized into just the hour we had today. For those of you who have attended here, you can see on the screen right now a website link for getting to the Telecom Access Networks pages on the NAB Show site, which will give you the full conference schedule of what we'll be talking about, continuing this discussion and many more things, and getting into more deep technology of Telecom Access Networks, what some broadcasters are calling the new last mile for the delivery of their content. Again, that's April 11th and 12th coming up in Las Vegas at the NAB Show, a new conference track and exhibit pavilion this year, Telecom Access Networks. And if you see on the screen in the box there, if you haven't registered yet, you can look at the TF27 code, put that in right when it's one of the first boxes you'll hit on the registration page, and you can get $100 off your registration fee. So we hope to see you out there. Again, this webinar will be posted for on-demand playback on that website, and those of you who have attended will also get an email with the link in there if you'd like to share it with your friends. That's it for us. We appreciate your attendance, and thanks again to Joe and Tom for the presentation today. This is Skip Peasy, Director of Digital Strategies at NAB, signing off the webinar right now. Thank you and goodbye.